Lawyers, what's your worst case of you should have said that sooner? My favorite, the plaintiff on the other side, so no attorney-client privilege issues here, was in court telling the judge that each of my clients, on separate occasions, raped and impregnated her without her consent. This was already highly improbable, because one of my clients was biologically female and couldn't have impregnated her. Then, in court, in front of the judge, this plaintiff abruptly mentions that she's never met my clients. Easiest win I ever got. Special ED case. School district was supposed to be providing services to the child in the home. Clients told us the school district had never sent anyone to provide the services. They hadn't heard from anyone in the district about scheduling, etc. Brought this up during a pre-hearing conference with judge and opposing counsel. After the conference, opposing counsel sends me pages of affidavits and documentation of all the times the school district employees went to the house and were refused entry by my clients for various reasons, or clients just didn't answer the door when they were clearly home. Clients had no explanation about why they lied to me. They fired us shortly after, and I was not sad. Here's another. I wasn't actually an attorney yet, I was clerking for a firm and helping other attorneys on cases. We had a personal injury case for a car accident. Guy got rear-ended by a very wealthy doctor. He was never going to be able to work again, mid-30s. Life completely ruined because she was staring at her phone while merging onto a highway going 15 miles per hour over the speed limit. The case was set for trial. That's an automatic red flag, as 99% of them settle. No one wants to risk the trial. Couldn't figure out why. We thought we would get him around 2.2 million. Other side was offering 700k. So I'm going through the massive file trying to figure out what they have that we don't know about. Looking at his medical, I saw he tested positive for meth a few months after the accident. I was part of the jury selection that morning, and we had 2 people with doctorates, several with masters and professional licenses, most college educated. Really not good for a guy who didn't make it through high school and was a laborer who decided to sit at home and smoke meth after his accident. Ended up settling right before the trial was supposed to start. We got a little more out of them, but far below what we expected. The guy was adamant about not settling, but we talked him into it. He would have been screwed as soon as they brought that up. In-house attorney here, but I interned for a judge at our Court of Common Pleas during law school. There was a case of a guy that asked 2 early 20 girls a ride from the mall to a gas station. He told them he would pay them cash for the trip. During that trip, he sat in the back seat and had advised that he had a pellet gun that closely resembled a handgun. He said he had only pulled it out to show the girls, but never did anything further. That had been his testimony during all the proceedings. He willingly takes the stand and the prosecutor is questioning him about the gun and how he handled it. This dude willingly admits that he held it to the passenger's temple threatening to shoot her with what she believed to be a real gun. He also corrected the prosecutor during questioning, telling him that he never stated it wasn't a real handgun. That jury verdict came about as fast as one could. Was prosecuting a simple assault and battery. Story I get before trial is baby daddy shows up and punches new boyfriend before leaving with the kid, who TBF he has custody of because mom tested positive for coke at birth. At the time girlfriend/baby mama tells police yup, that's what happened. But, in the meantime she and new boyfriend broke up and now she is back with baby daddy, so her story has changed and she is saying it didn't happen. She isn't credible, so I discount her new version of events and still put the case in front of a jury because the victim is adamant and there was an injury to his face. Defense obviously puts the girl on the stand, where it first comes out that she and the victim weren't Netflix and chilling as reported to police, but were actually doing cocaine and ignoring the baby. The baby daddy apparently knew she did coke at this location, so when he saw her car there he went and pounded on the door demanding their kid. She then says that the victim hit himself in the face to make it look like he was beat up. As she is saying this, the victim starts hitting himself in the head and yelling no, 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 like the special needs kid the school makes wear a helmet before storming out. The jury went with not guilty, and I understood. So, not a lawyer yet, but I interned at a family court helping during hearings. There was this woman filing for custody of her children, and her lawyer was pretty confident they'd win, since in my country women getting the custody is almost an unspoken rule. In the rare cases they don't, either they don't want it, or there's a very strong reason for the children not to be with their mother. So, as I was saying, her lawyer seemed very confident. It was practically a one case. Until her client's ex-husband mentioned in the middle of the hearing that his ex-wife was an addict and lived in a non-monogamous relationship with 2 other addicts. To make matters worse, the woman's parents confirmed his story. The lawyer very obviously did not know about it and was visibly pissed at her client. I swear I saw her mouth to the woman, "You'll have to find a new lawyer." A person involved in a motorcycle accident who sustained legitimate but not serious injuries. CCTV showed the incident. They were very much not at fault. They decided this was their big payday, claimed they could barely walk, had PTSD, serious back trouble, would never work again. The whole 9 yards. They neglected to tell their lawyer they had been 1. Working a manual labor job, 2. Riding motorcycles again, 3. Did a bungee jump. All of which we caught on video / they documented via social media. They did not get the multi-million-pound settlement payment they expected and were pursued for fraud. It was a fun phone call after we sent the tape full of evidence. Learned while my client was on the stand that she had a little bit of a drug problem. She disclosed immediately after that she was going to fail the drug test the judge ordered because she had been a daily meth user for years. She was stunningly gorgeous, had held the same job for over 25 years, and was a rockstar mom to a kid with special needs. Unlike 90% of my clients, she was always on time, responsive, and did everything I asked. To date, the only high-functioning meth user I've met. But freak, that hearing would have gone quite differently had she mentioned that to me beforehand. FYI, most of the time we can deal with bad facts. At the very least we can give you the advice you need to hear. But there isn't much I can do with surprise facts in the middle of a trial. I filed a bankruptcy for a person. A few weeks later, they indicated that a creditor continued to contact them and had taken money out of their bank account, which is obviously a big no-no for people in bankruptcy. It was Monday. I knew that if I wanted to file for sanctions, I had to file the motion by Friday, so I wasn't going to jump right into it. It's best practice to try to get a creditor to correct their behavior first. I called the original payday loan store. I called the national branch. They took messages daily. Nobody was contacting me back. I asked for supervisors. Nobody was willing to talk about the situation, and I became increasingly frustrated. I'm not a yeller, and I'm not particularly forceful, but even I was reaching my limit. I called my client daily to explain that it made no sense that they were being evasive, but I was working as hard as I could. On Friday, I talked to some lower level grunt and explained that I needed a call back in an hour from a person who can clarify the situation, or the sanctions motion is being filed. I read off my time spent on the case, which would translate into thousands of dollars in sanctions if we were successful. I finally get a manager. He, very politely, tells me that the client took out the loan after the bankruptcy was filed. I remember deflating like a popped balloon. My client had taken out a relatively big payday loan a week after the bankruptcy. They confessed that they knew it wasn't included in the bankruptcy, but thought the lender would go away if an attorney got involved. That's probably mild compared to the things that I see in bankruptcy, but most I probably shouldn't disclose. One of the major tenets of bankruptcy is that a debtor has to make a full and honest disclosure of their income, expenses, assets, and debts. So naturally, there are tons of reported cases of people hiding things to try to get out of their debts without surrendering assets. Had a client charged with being a convicted felon in possession of a handgun. She had been in a car that had gotten into a shootout on the interstate in the middle of the night in a rural area at least. She was the passenger and her car pulled into the state trooper post in the county I practiced in. Her car was shot to shit, so it was obvious something happened, but there was a gun in the car. She had a 30-year-old felony theft conviction, so she was charged. She had some crazy story for what happened, but it was obvious that it was a drug deal gone wrong. However, that didn't matter for her charge really. The discovery was really light. The driver of her car wasn't a convicted felon, and it didn't appear the state police had investigated the fact there was another car obviously shooting at my client, even though the genesis of the shootout was just up the road in that same post's jurisdiction. Short of it was she had some legitimate defenses. I had met with her multiple times, discussed her case in depth, and was preparing for trial. About 2 weeks from trial, in passing, she mentioned that a state trooper had interviewed her at the state police post, which was annoying because at this point the case was 7 or 8 months old. So I look through the discovery again, don't see anything, but file a motion asking for any recordings of interviews. Sure enough, the prosecutor was sitting on it, which is shady as freak, unethical, and common practice for that prosecutor office. I get the interview and all of 4 minutes and she tells the cop not only did she know the gun was in the car, but that she had been the one shooting. That pretty much killed every defense I had. We had a come to Jesus talk the next day and she took her offer, which was the minimum of 5 years to serve. I was representing a man that was accused of sexually assaulting the young daughter of his girlfriend, who was married to another man. The key issue was whether or not my client's DNA profile should have been at the scene. Only skin cell tissue had been recovered, not seminal/bodily fluid DNA, and it was not an exact match, but rather a match to a profile that included him. A few weeks before trial he finally told me that the woman's other son was likely his. They had been having an affair for more than 5 years. The fact that the boy shared his DNA was a pivotal reason that the DNA profile would have been present. A big issue was a language barrier, as my client did not speak English, and we used an interpreter for all of our communications. Had a guy with a DUI asked about any criminal history, he said no. So I started the paperwork for ARD for him. It's the first time offense program that seals the record and drops the charges once completed. Get to the courthouse, talk to the DA, find out the guy had another DUI a year prior. Also was on probation from the first one still. His excuse for not telling me was the first DUI was made up, and he wasn't intoxicated, but pled guilty anyway. Unfortunately I ended up representing him for both bases, did not get paid nearly enough for the crap I went through, but I did manage to keep him out of jail, so he could take care of his elderly mother. Made him give up his vehicles though.